All right. So we are at start time, so we'll go ahead and start digging in. As mentioned, thank you everyone for joining here today. We're going to go through everything you need to know about GDPR and specifically focus on, at the tail end of this, what you need to be doing right now. One thing that we've noticed in working with a lot of our US-based and non-EU based clients is that they're a little bit behind in terms of preparations, and there's a little bit of confusion, especially from the marketing, analytics, and the media side of things. Exactly, what does GDPR pertain to? What are the tags? What are the platforms that they really need to be cognizant of? And what are the things that they need to start doing and where to start in order to be able to address this for any visitors to their site in the EU, and then also, especially with some of the more recent events, some potential privacy types of things that's going to continue getting more notice and more attention in the US as well. So what we'll do here today is go through all those different items. So just to start, a little bit of general housekeeping about Tag Inspector and your presenter, me. So that's me. I'm Lucas. I'm our Tag Inspector product manager, and I also do tag management consulting for us at Tag Inspector as well as InfoTrust. Tag Inspector is a product of InfoTrust. On the InfoTrust side of the house, we do digital analytics consulting and product work, with Tag Inspector being our primary software product. Tag Inspector is a tag auditing tool, and we help thousands of organizations on an annual basis in terms of optimizing tag architecture, validating data collection, as well as implementing processes around tag governance and ongoing tag policy management. And that's starting to bleed a little bit into the privacy work that organizations are having to start really taking care of. We do a number of digital marketing training programs, including these types of webinars, and we have offices in Ohio in the USA, as well as in Dubai in the UAE, and then in Barcelona, Spain, which is where I am currently based. So one other general housekeeping item that we always have to cover when talking about GDPR and any type of legal initiatives. This is not legal counsel. I'm not an attorney. I don't want to be an attorney. I want to be able to provide you with the information necessary and some educational information around GDPR. At the end of the day, hopefully this can help you, create some opinions and create some next steps for what you need to be putting in place. But at the end of the day, any type of privacy policies or privacy notices, as well as the fully wrapped up solution for GDPR and privacy regulation in general, needs to be reviewed and approved by your own legal counsel. And I would definitely advise you to do that before putting anything in place. Cool. So none of those general items are out of the way. Just to quickly kind of run through our agenda and the things that we're going to be covering. So the first thing is just a general overview of GDPR, as well as some of the e-privacy directives that are present within the EU. And the e-privacy directives are going to be something that are going to continue coming up. Right now they're on a country-by-country basis, but there is an ongoing effort right now to codify everything across the entire EU. That's going to make things a little bit more tricky when it comes to any type of tag usage, because it's going to apply directly to cookies, email, things like that specifically. Once we go through just a general overview of GDPR and those e-privacy directives, we'll get into the 6 basic principles of GDPR. Those are the 6 main things you really need to understand and really need to make sure you're adhering to. We'll go through the different lawful basis for processing, which is step 1 for processing any type of personal data for clients. We'll go through what the rights are for individuals, making sure that all of those are being upheld and adhered to. We'll go through what it means for your organization in terms of accountability and governance, what you need to be responsible for, the extent to which the regulations apply to your organization as the controller or the person or the organization person that is determining what data is being collected, processed, and how it's being used. We'll also go through specifically some items around the privacy notice. That's one thing that's going to be really, really important. It's giving that visibility to clients and users of your website. So we'll go through some specifics that you're going to want to make sure you hit on within your privacy notice. And then we'll get into some of those further specifics for what it means for you, especially as, again, an organization outside of the EU, or everyone has some users, some visitors from EU countries, but if your main focus is outside of that area. So what it means for you, what you need to be thinking about, and what you need to be putting in place as you prepare for GDPR, which goes into effect. And don't forget, it's May 25th of this year. At the end, we'll just go through a quick summary and a Q&A. If you have any questions at all, please do not hesitate. Drop them into the little question bar, and I will, happy to answer anything as we're going through. Cool. So to start, general overview, GDPR and the e-privacy directive. So one thing, GDPR is regulations. What these regulations do, they protect fundamental rights. In this case, GDPR is protecting fundamental privacy rights and protecting those privacy rights for individuals as human rights, basically. So the regulations meant to protect fundamental rights of natural people, of individuals. Directives, on the other hand, such as your e-privacy directives, they're specific and they're special, and they're in reference to specific data points or specific types of data that are being collected. So your e-privacy directives right now are going to be focused on cookie collection, as well as things like email collection and the use of email. One piece of the e-privacy directive that you've probably come into contact with, especially if you have some sites within the EU, is sites require some sort of consent for cookie collection, or certain countries require different levels of consent for cookie collection. Under the current e-privacy directives, implied consent, such as just a banner that says, by continuing to use the site, we are setting cookies, and then an opportunity for them to opt out in a privacy notice or something like that, is the standard. That's all you have to have at this point. Some of the new e-privacy directives and what's being worked on right now, expected to, in some shape or form, go into effect in the next year to 2 years. People are really pushing for explicit consent for any type of cookie-based tracking, as well as any explicit consent for any type of collection and then usage of email. So be on the lookout for those. But for the purpose of the discussion today, GDPR is a regulation focusing on protecting fundamental human rights for individuals, whereas those directives, which will come up a little bit in the conversation, are specific and special for specific data types. Some important definitions for GDPR, and then just an overview. These are going to be some different things that we're going to be using throughout the discussion today, so it's really important to understand exactly what each term means. First thing to keep in mind, as I mentioned on the previous slide, the intent of the regulation is to instill basic privacy rights as human rights, meant to codify, what is proper adherence to privacy, and how should that be protected for individuals. One of the big things that people are, have at least heard about when it comes to GDPR is the punishments. The punishments are no joke. So 2 different levels based upon how it is that a breach has occurred. So the first level is up to 10 million euros or 2% of annual global turnover, whichever is higher. So for huge organizations, we're talking about billions of dollars there. The second level of punishment is up to 20 million euros or 4% of annual global turnover, whichever is higher. How those are applied, basically that first level, the 10 million or up to 2%, is for if you mishandle a breach, basically. So that scale is used if a breach happens or some sort of a breach happens and you aren't notifying the proper authorities, you aren't doing the right things in response to that. The up to 20 million euros is if a breach basically has occurred. So any type of breach that happens under GDPR, that's where that actual breach and how it is that you're handling it and what type of things you have put in place, those are the things that are judged for that 4% annual global turnover scale. Then the 10 million euros is you had everything in place as expected, but there was some sort of a breach that happened outside of your own fault. How you handle and how you address that breach would be that first scale. Also important around the punishment, those two are just administrative actions that the governing body can take. It also, though, explicitly allows for compensation claims for damages suffered by an individual. So what this means is individual lawsuits for privacy violations, as well as class action lawsuits that can result as well. So if you are not protecting the privacy rights of individuals at a pretty large scale, not only are you going to have issues from the regulation governing bodies, but also in the form of private lawsuits as well. And then obviously, finally, when it comes to punishment, reputation damage and loss of consumer trust. People can't trust you. They don't, they're not going to give you their information, not going to allow you to use their information, not going to buy from you or use your service. One super important thing to mention, and it's something that the governing bodies have mentioned over and over and over again, when considering fines, considerations will be taken into account. This means if you have processes in place, if you can show that you are trying really hard to adhere to the regulation, and you have all of the necessary pieces in place that we'll go through here shortly, that you have protections there, that you are considering privacy, through all phases of your product design and user experience design, those considerations will be taken into account when it comes to the punishment. It's not a one-size-fits-all. You're in breach. Give us 4% of your global annual revenue from the previous year. It doesn't work like that. Everything is going to be judged based upon the unique situation that is being faced. It's also important to remember, before everyone starts really freaking out about the punishments and everything that needs to go into becoming compliant with this, it's important to remember that you are not the only one affected by this regulation. Everyone is. Anyone that's doing any sort of business or has any sort of users and processing personal data of users in the EU is covered under GDPR. So it's kind of like the analogy where if you're running from a bear, you don't necessarily have to be faster than the bear. You just need to be faster than the other people that are also running away from that bear. So keep that in mind as you're working through this, and work diligently to get everything in place and make sure that you have defensible positions for everything that you have in place and all the decisions that you're making when it comes to collection, processing of personal data. But it's not something to stress about too much. Cool. So that is the general intent, punishment, things to keep in mind. Now I want to go through those important definitions. We'll try to run through these pretty quick. First one is the controller. So the controller is the body that determines the purpose and means for processing personal data. Basically, at the end of the day, the controller is going to be you. Your organization is going to be the controller of that data. You're the one determining what platforms, what tags are going to be running on the site. You're the one determining what forms look like, what data is collected in forms. You're also the one determining where that data is going, how it's being used, how it's being processed. So that's kind of the core for the controller. Some other organizations could also be controllers within your ecosystem as well. If you are sending data to, say an agency partner, and they're doing their own autonomous analysis of that data and making decisions on your behalf for purposes of targeting or media and things like that, they then become the controllers as well in that sort of an ecosystem. But they are also, and all platforms that you're using are also processors. So a processor is the body or the tool or the entity that's responsible for processing personal data on behalf of a controller. So in the case of, say you're using something like Google Analytics, the organization is the controller. You're determining that, yes, I'm using Google Analytics for my site behavioral analytics purposes. You're determining what data is going to be collected from users. And then the processor in that case would be Google, because on your behalf, they are processing that personal data within GA. So who does GDPR apply to? It applies to anyone that's collecting personal data. And now that I'm using that term a lot, it's important we define it. So any information that can be used to directly or indirectly identify the identity of a natural person. A natural person is an actual living, breathing human being. So it's important to note here, pseudonymized data can fall under the scope of GDPR depending upon the difficulty to attribute the pseudonym to a particular individual. This means a cookie ID or a fully randomized client ID. If it can be used as a key in any sort of a way to identify an individual, or if it's fully unique to be able to identify an individual person, it would be considered personal data. There's still a little bit of gray area here when it comes to, for example, a client ID. A client ID points to an individual browser on an individual machine, not necessarily a natural person. The argument can be made that multiple people could be using that browser, but if you're doing things like cross-device and user IDs, even though that's a pseudonymized data point, it's not like an email or anything like that. It might be a random identifier, but because it's persisting for an individual across multiple different devices, types and things like that, that's going to be considered personal data for sure. Yeah. So it expands. It's not just personally identifiable information. You don't have to be able to identify that person, I guess. You can also be indirectly identifying a person. Just the representation of this data point can say, yes, this anonymous person, it represents them. That's covered under GDPR's personal data. Processing is another important term here. Any operation performed on personal data or on sets of personal data. One important thing about processing, that includes just accessing the data, running a report, downloading it. So even if you are just downloading information from a platform, or you're opening up an attachment that has personal data being sent to you from some sort of a advertising platform, that is still considered processing. Any accessing, any number crunching, anything that you're doing with personal data is considered processing. Cool. So that's a high-level overview. Those are the main definitions we need to understand. It's the intent of the regulation and what it's hoping to be able to set out and achieve. Now, let's go through the primary principles for what is covered here. So there's 6 main principles that are covered under GDPR. Those 6 principles are: number 1, personal data shall be processed lawfully, fairly, and in a transparent manner. We're going to cover this in much more depth here in one of our next sections, but basically what it means is that data has to be, you have to have a legal basis for processing or for collecting that information, and it needs to be transparent in why it is, what that data is being used for, and people need to have the ability to, one, understand what data is being collected, where it's going, how it's being used, what the effect is on them, but 2, be able to have the transparency and have the ability to opt out of any kind of processing that's going on. Second principle is personal data shall be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. Further processing for statistical purposes shall not be considered to be incompatible with the initial purpose. This just kind of expands on number one, in that whatever the purpose is that you have, your lawful, fair, and transparent purpose for collecting that data, whatever you're notifying individuals that this is what we're using your data for, this is how we're processing it, that is the only thing that you can process that data for. So no longer can you just, let's collect all this stuff and we'll figure out something to do with it down the road. No, you need to only be using data and only processing it for the explicit purpose for that you are notifying users and letting them know. If you want to process data that's already collected for some other purpose, you're going to need consent from the individuals in order to be able to do that. You can't just say, hey, we have a new reason for doing this, and walking through, and I think this is going to be good. Let's go ahead and do it. Have to process data for the explicit reason that you collected it for. Number 3, personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. This kind of goes back to my previous point. Only collect, only use data that accomplishes the goal that you're setting out and that you're explicitly stating. This is what we're processing the data for. We only need XYZ in order to be able to do that. You can't just collect a bunch of stuff and try to figure out later what exactly to do with it. Number 4, personal data shall be accurate and, where necessary, kept up to date. Every reasonable step must be taken. Inaccuracies be erased or rectified without delay. Basically, it's on you as the organization that has collected and is processing that data, or as the controller, to, if data is inaccurate, you need to be able to identify that. And if a user notifies you that, hey, this information is inaccurate, you have to have a mechanism in place in order to be able to rectify anything that is wrong, basically. Data that you have must be accurate, and if it's identified as not being so, it needs to be updated. Number 5, personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. Basically, this just means once you've done whatever it is that you've explicitly stated you're collecting and processing that data for, it needs to be removed. As well as within the process of utilizing any type of personal data, it needs to be obfuscated unless it is in processing, basically. Personal data needs to be protected from a technological standpoint, and risk management practices just need to be put in place that personal data is not available to be hacked or misused outside of the purpose for which you're processing that data. And then finally, the sixth principle of GDPR, personal data shall be processed in a manner that ensures appropriate security of the personal data using appropriate technical or organizational measures. This is just saying you need to have organizational processes in place in order to be able to ensure that personal data is being protected, as well as appropriate technical measures in place to be able to ensure that personal data is protected. All of these different principles, these are kind of the core underlying fundamentals that you need to be familiar with. In any sort of scenario in which you're collecting, processing, using, transferring, storing anything with personal data, you need to keep these 6 fundamentals in mind and just ask the question, am I following the 6 principles with the personal data that is collected and being processed? Super important here, Article 5.2 of GDPR, the controller shall be responsible for and be able to demonstrate compliance with the principles. it is super, super important to have documentation around the personal data that's being collected, the processing that's being done, why it's being done, all of those things. You need to have documentation that you can use to prove, in the case of the governing body, coming after you or asking questions or sniffing around, that you have a defensible position when it comes to the personal data that's been collected, processed, used, and you have all of those necessary safeguards in place, and you're able to prove it. It's on you, the controller, in order to be able to do so. This also, responsibility extends to any processors that you're working with. So those all have to be GDPR compliant as well, and we'll talk about it a little bit when we get to talking about accountability. That also, the responsibility lies on the controller to make sure that any processors that they're using are GDPR compliant. So the number one piece for the principles was you need to have a lawful basis for processing any type of personal data. So I want to focus on those specifically. A lot of people and a lot of, especially organizations outside the EU, people are really focusing on consent. Oh, we need a consent mechanism. Oh, we have to get explicit consent from users. True and false, and I'll explain why. There are technically 6 different lawful bases for processing personal data. You can use any one of the 6. Overall, for marketing, advertising data, really only 2 are going to apply, but we'll dig into that. Some things to keep in mind when it comes to your lawful basis for processing. It must be determined before the processing. Again, you can't just collect information thinking like, oh, this might be relevant, and then after it's processed, put together your rationale and reasoning for doing so. Before you collect, before you process any of that personal data, you have to make sure that you've identified what your lawful basis for doing so for that collection and that processing is. It also must be necessary. Processing of the data has to be necessary in order to be able to accomplish whatever the goal is that you're explicitly stating for how that data is going to be used. And then your privacy notice must specify the lawful basis for processing. We'll go into a few more specifics for that within the privacy notice section. And as mentioned, there are 6 lawful bases available for processing. So first, let's run through what those 6 different bases are. One important note, none is better than the others, but depending upon the situation, there will likely be one reason that is more appropriate than others. So the first is a contract. If for the execution of a contract, you need some sort of personal data, then that's a legitimate, lawful basis for processing that data. Number 2 is a legal obligation. If you're legally obligated in order to be able to fulfill some sort of a legal obligation, you need to collect some sort of personal data or process personal data for a user, for a client, you can do so. Vital interest, this is basically if you need to use or process some sort of personal data in the interest of saving a life, you're able to do so. Public task, this is more for just public bodies, but again, if for the purpose of executing a legal public task that is necessary, you can process personal data. Those are kind of 4 just to be aware of. For marketing, advertising, the 2 that are going to be most important, first is legitimate interest. We'll dig much deeper into this here in a moment. And then the final one is consent. Again, consent is just one of 6 legal bases for processing. Not every single processing activity of personal data requires explicit consent. It's a common misconception. As mentioned, for purposes of marketing and advertising, we'll be working with either consent or legitimate interests. So, to start with consent, want to highlight what the difference is between the current regulation and the current environment for consent versus what is covered under GDPR. So what changes under GDPR? Under the Data Protection Directive, which is current, any freely given, specific, and informed indication of a user, his wishes by which the data subject signifies his agreement to personal data relating to him being processed. This is where that implied consent becomes allowed. Any indication signifies agreement to personal data being processed. Under GDPR, the definition is modified slightly. Any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. The big differences here are the addition of that GDPR clarifies that the indication must be unambiguous and provide a clear affirmative action. Explicit consent, consenting to the processing of the personal data for the explicit reason stated is what's going to be required here when it comes to consent. So, what are some of those requirements? These requirements are clarified, I guess, by the governing body that oversees these. We're still waiting on some final clarifications when it comes to consent. Those are expected at the beginning of April, really wanting to cut it close. But those will be out pretty soon. As of now, what are some of the requirements for consent? No pre-tick boxes, no implied consent, clear and specific statements of requests. Consent must be separate from other terms and conditions. Can't package privacy and T's and C's together. Specific right to withdrawal consent. Also, there's no set time limit, but it needs to be reasonable and defensible for the amount of time, basically, that you're utilizing data and being reliant upon consent. And then consent request messaging requirements. There are specific requirements for the messaging that needs to be used. Basically, it just needs to be easily understood. Not just a bunch of marketing and advertising jargon. So that's consent. If you are using consent as your lawful basis for processing personal data, those are the things that you need to be following. It needs to be clear, it needs to be explicit, it needs to be reflected in your privacy statement. People need to have the ability and the ease of opting out or removing their consent. The other legal basis for processing which you can use is legitimate interest. And this is where we're starting to see a lot of people kind of work in the gray areas of the regulation. So in Article 6.1(f), it explicitly states processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interest or fundamental rights and freedoms of the data subject which require protection of personal data, in particular where the data subject is a child. So basically this means that if processing is necessary for the purposes of your interest as a business, as long as the privacy or fundamental rights and freedoms of the individual are not being compromised and you can prove it, then you can use legitimate interest as your basis for processing. GDPR in one of the recitals, which are some clarifications at the front of it, it explicitly states the processing of personal data for direct marketing purposes may be regarded as and carried out for a legitimate interest. So this leaves the door open, basically, where you don't have to get explicit consent when it comes to collecting personal data for purposes of marketing and advertising. Now, if you're using legitimate interest, you need to make sure that you are going through the proper steps in order to be able to justify and have documented that, yes, I have a legitimate interest, and yes, the fundamental rights and freedoms of the individuals are not being adversely affected. So, things to keep in mind when it comes to legitimate interest. So you must be able to show that the use of personal data is proportionate, has minimal privacy impact, and people would not be surprised or likely to object with how that data is being used. So a super relevant example right now in the US is with how Facebook is being used in order to create Facebook data of users was being used by organizations in order to be able to create political advertisements. In terms of the collection of that data, a lot of it's, several years ago, before privacy notices and whatnot were updated, you could access, if an individual gave access to an application to basically access and use their personal data from Facebook, you could also, based upon that indication, access the personal data of their friends. So if a friend of mine, started utilizing some sort of an application on Facebook, then that app developer would have access to my personal information. And when my personal information would just be like the proclivity to like certain things, as well as my demographic data, access to my photos, different tags and classifications that they use in order to just classify me as a person. I would not expect, just as a general user of Facebook that has a friend that played with some application, that the developer of that application would be able to, several years down the line, take my personal data, use it to create some sort of a psychographic characterization of me, and then target political advertising to me as a result. That would fall definitely outside of using personal data for something that has a minimal privacy impact. Arguable that it has a minimal privacy impact, but people would be surprised and likely to object to the use of just information that I'm putting on a social network in order to be able to use it in a malicious way like that. So that's an extreme example, but that's the first thing to keep in mind for legitimate interest. You also need to make sure that the legitimate interest, or how you're processing and using that data, is compliant with privacy directives. Again, that's kind of on a country-by-country basis. I don't want to get into that too much because that's a whole different rabbit hole, and we need to focus on the high-level points right now as organizations outside of the EU. There are three super important elements that you need to be keeping in mind when using legitimate interest as your lawful basis for processing. And three tests that you need to do as you're thinking through, is this okay, and your rationale for doing so, and documenting your defensible position. First is the purpose test. What is the legitimate interest? What is your legitimate interest? Why should the business be able to process personal data or collect this personal data and use it in whatever way you're proposing to? What is your benefit? Number two, the necessity test. You have to prove and be able to show that the processing is necessary in order to be able to achieve your stated purpose. So if your stated purpose, or your goal, or your purpose is to, better target individuals in like search advertising. If there's ways of doing that without collecting, user ID or email and things like that of individuals, and you can't prove a significant improvement because you are collecting that type of information, or maybe an industry best practice or something like that, it wouldn't be necessary. You have to be able to prove that it is necessary to collect and process that personal data. And then number three, you need to do a balance test. You need to balance the interest of your organization against the subject's interests, rights, and freedoms. That's where it comes in that, minimal privacy impact, people would not be surprised or likely to object. You need to include the details of any legitimate interest in the test and evaluation that you're doing within your privacy notice. People need to know exactly what the legitimate or lawful basis for processing of their personal data is, what personal data is being collected and used and processed within each platform and within each processor, as well as know what the effect is. What is it? What is the effect of them? For you collecting a user ID that you're then using within advertising to better target ads personalized for them. Um, you know, Targeting of ads is something that would likely be considered minimally intrusive. It's not negatively affecting that individual in any way. So that would probably be okay for a legitimate interest, but the user has to know that this is the data points. These are the data points that are being collected. This is how it's being used, and this is the result for me. In the context of marketing, the right to object is absolute. You must stop processing as soon as someone objects. This is important to note just because even if you're using legitimate interest, if someone says no, don't use my data for that reason anymore, that is, again, the right to object is absolute. You must stop processing. You must delete their data immediately. So, walking through that legitimate interest, you can use a legitimate interest assessment. You need to keep a record of these. Again, it's going through and identifying, what is the purpose? What is your legitimate interest? Asking questions like, how important are the benefits? Why do you want to process the data? Are there wider benefits to processing? Things of that nature. Number 2, you need to apply the necessity test. Does processing actually further the stated interest? Is there a reasonable way to accomplish the interest outside of processing of the personal data? Is there a less intrusive way to achieve the same end result? And then finally, doing the balance test. So you need to balance the benefit to your organization against the risk to the individual user's personal data. That balancing test is, there's no definitive right or wrong. Unfortunately, there is no set equation or anything of that nature. You just need to be able to lay out, what is the actual risk to this individual's privacy? What is the benefit that is being conferred? How is this data being used? And does it, make sense? Is it reasonable for us to process the information for this particular purpose? All this has to be documented. You have to have it in order to be able to defend your legitimate interest as the lawful basis for processing that personal data. So those are a couple of the initial keys there. Now let's look at the individual rights for individuals. So individuals have some basic rights. Number 1 is the right to be informed. What data is being collected? How is it being used? 2, they have a right of access. They have a right to access their personal data that you have collected and processed. Right to rectification. That's going back and they have a right to having accurate data. And if something is inaccurate, of getting that updated. Number 4, right to erasure. This is what many people refer to as the right to be forgotten. If someone requests that you delete and stop processing their personal data, they have a right to do that, and a right for you to delete that information. They have a right to restrict processing, which is kind of just an extension of the right to erasure. You can keep the data, but stop utilizing it for anything. Number 6, a right to data portability. So if one platform or one tool has a user's data, they have a right to request that information in a usable format so they can take it and give it to someone else to be able to use in the same way for processing. They have a right to object to any sort of personal data being collected and processed. And then finally, they have rights in relation to automated decision making and profiling. Basically, you cannot utilize personal data of anyone to profile them in order to put them into a segment that changes the legal basis or the contract that's being offered to a user. These are the 8 rights that are defended under GDPR, and again, similar to the 6 principles, these need to be things that you keep in mind when it comes to how you're processing, how you're collecting user information, and with the different tools and the different processes that you have in place, is it possible even to be able to adhere to these rights for individuals? In terms of accountability and governance, so as mentioned before, Article 5.2 summarized accountability. It's required that you demonstrate compliance with the 6 principles, and GDPR explicitly states that it is your responsibility as a controller. Your organization is your responsibility for all the data that's being collected, all the data that's being processed. Even if a breach or something like that happens within one of your processors, at the end of the day, that's also on you. Because that processor wasn't fully vetted, that processor, wasn't fully maybe the necessary safeguards weren't in place. Now, if you did a full assessment of your various different vendors, you had data sharing agreements in place, everything was assured that yes, it is up to snuff. At that point, you would have a defensible position. But you need to be able to have that defensible position in order to be able to potentially win in a scenario like that. You need to be able to prove that you have some organizational measures in place. Kind of alluded to these earlier, but privacy by design, data protection by default. You need to have documentation, privacy notice, records of consent if you're using consent, controller processor contracts or data sharing agreements. And then potentially data protection impact assessment reports. It's also really important that you are able to map the data flow or walk the data. So understand what personal data is being collected, where is it going, how is it being used, how is it being processed, when is it fully done being processed, and when is it deleted. You need to be able to identify these things for any personal data being collected on your site from a user in the EU, and then also to make sure that throughout that entire life cycle, the GDPR is being adhered to. I don't want to get too deep into these because, again, I want to be able to cover some of the highlights here. Privacy notice. Really what's important when it comes to the privacy notice is these items to cover when you're planning. So in respect to the data, you need to be able to have who, what, when, why, how, and then is it likely to cause harm. So you need to include that information and then further specifics about what data is being collected, where is it going, what platforms, what is it being used for, why is it being collected. All of those things need to be clear and transparent to your users so that they can make an informed decision about their personal data. Is it okay? Should they be opting out? Those sorts of things. For those, we'll share obviously the slide deck so you can have some more of those specifics when it comes to that privacy notice. What I really want to get to, and why I rushed the last couple of slides, is being able to discuss what this means for you, specifically in the marketing and analytics and advertising space, especially for an organization outside of the EU that you're not living and breathing this stuff every single day. It might only be applicable for a small subsection of your users and your visitors. So first, when it comes to analytics data, if you have just a standard out-of-the-box setup with analytics, no user ID setup or anything like that, the only potential personal information would be an anonymized cookie ID. With an analytics data set that likely does not fall under personal data in GDPR, or with that standard analytics data set, it likely does not fall under personal data in GDPR. If you're using that information for aggregate types of reporting and statistical uses, and again, there is no type of persistent identifier for an individual across devices or anything like that, likely can get around any sort of issues when it comes to GDPR. You're not collecting personal data. Nothing to worry about there. Cookies, though, are covered in the e-privacy directives. So if you have a focus of attracting users from some of those different countries, it's going to behoove you to look into the e-privacy directives for that, because like implied cookie consent, things like that might be relevant. When it comes to digital media and advertising, here there's a much richer data set of personal and behavioral information. There's always going to be an identifier of some sort that can be used as a key to be able to match together different data sets. Because at the end of the day, you're trying to understand, who is this individual, what do they consume, what do they like, and how can we best target them. So data collected by your digital media and your digital advertising platforms is likely to be treated as personal data under GDPR. There's also some profiling that's going to occur there. It's not going to fall under the special rules of profiling as long as you're not adjusting offers that are being offered to users based upon their profile. And when I say offers, I mean like pricing. If you're trying to charge someone more for a cruise because they match a particular profile of an individual that is or affluent, then that is going to be profiling that would be covered under some more stringent regulations. Basically, you can't do it and still be compliant with GDPR. So that's one thing to keep in mind. Analytics data, probably not classified as personal data, should be fine. Digital marketing and advertising, definitely probably going to be personal data. You need to have GDPR in mind for the processing of that information. So what do you need to do? What do you need to, how can you begin to get ready for this? Especially if you're kind of behind the ball in terms of the preparations right now. Number one, you need to understand what is on your website. You need to do a tag audit. You need to understand what are the platforms that are processing information on my site. Am I even aware of all these things? Do we have owners for all of these things? All of these things are potentially processing personal information, especially the advertising platforms. Do we have data sharing agreements in place with these different tools and these different vendors? Are they fully vetted? I mean, again, you are responsible at the end of the day. You are accountable for personal data that is collected on your site. Even if a breach happens with one of the processors, you're going to be especially hung out to dry. A reasonable defense is not going to be, I didn't even know that was loading on the site. You have to understand that, you have to know where that data is going. So number one, just get an inventory, understand what the platforms are that are loading on the site. And then once you understand all those different platforms, you need to start asking some questions. What is the lawful basis for processing? Well, I guess taking a step back, number one, am I collecting personal data? Is personal data or something that could be construed as personal data being collected by by this particular platform? If yes, then what is the lawful basis for processing that data? Again, marketing or advertising, it's probably going to be it would be either consent or legitimate interest. If you're relying on consent, can you prove that you have consent? Does your consent mechanism, is it fully up to snuff when it comes to the guidelines and requirements under GDPR? If it's legitimate interest, can you document, or do you have documented, and can you prove that you went through those various different tests and you have a defensible position? You need to ask, are the rights of the individual being adhered to, for the data within that platform? That goes back to vetting your partners, making sure that, there is the ability for data portability and data erasure, things of that nature within those different platforms. Can you demonstrate adherence to the 6 principles with, all of the processes that you have in place? And then is everything properly documented within the privacy notice? Do your users, are they properly informed as to the data that's being collected, where it's going, how it's being used, what the end result is? Once you are able to do that for each platform, you're likely going to have some work to do in terms of getting data sharing agreements in place, in terms of making sure that you have documentation and you have all kinds of those safeguards already in place. Once you have that, though, you then have a solid basis of just a policy. These are the things that are approved. These are the things that are fully vetted. These are the things that can be collecting and processing personal data on my website. Moving forward, you need to implement some of these different pieces into different processes that you just have as an organization. Number one, GDPR evaluation should be a part of the purchasing and onboarding process. Any new tool that you're looking at using for analytics and advertising on your website, you need to ask those questions. Is this GDPR compliant? How am I going to be using this? What data is being collected? Am I collecting personal data? If so, how am I processing it? And then those things need to be reflected in things like your data sharing agreement, maintaining documentation, legal basis, all of those good things, and then also wanting to get some sort of process in place to monitor on an ongoing basis your site to make sure that no unvetted and unauthorized tags are not popping up and potentially collecting personal data where they shouldn't be, which again, you're going to be responsible for. So I know that was a lot. There's a lot there within the regulation. So in terms of just kind of a summary, what we've covered today, high level, what GDPR is, what it's really focused on, why it was put in place. It all really boils down to, are the fundamental human rights in respect to privacy of my users being followed? And am I doing the things necessary in order to be able to make sure that privacy of my users is paramount, really. We went through the 6 different principles. We went through the lawful basis for processing and the keys to keep in mind when it comes to consent as well as legitimate interest, because those are the 2 that you're going to be using for marketing and advertising. Went through the different rights for individuals under GDPR, things that you need to make sure are adhered to. Went through accountability and governance, what that needs to look like for you. Quickly, admittedly, went through some of those specifics for the privacy notice, but as promised, we'll follow up with some more specifics for that and a few links, and then also covered what it means for you. Basically, at the end of the day, again, what it comes down to is you need to understand what is collecting information on your website. You need to understand, who are your users, what percentage of your users are coming from the EU, how do we want to handle these platforms that are collecting personal data or what would be considered personal data under GDPR. How do we want to handle it for those users? Do we want to go ahead and get these GDPR principles in place for all users, potentially earning some more trust for even my US-based users? And then you can continue using platforms. I mean, we have some clients that are just blocking tags from loading when a user is accessing the site from the EU. That's one approach, depending upon your how much that's going to affect marketing, advertising, and the proportion of users from the EU. But there's many different approaches out there. You can choose the best one for you. But first, you need to understand, what are the platforms there? Is personal data being collected? And then, if so, is the regulation and the requirements of GDPR being followed in those cases for processing? And then, making sure that you have the correct things in place in order to be able to get to that point. Woo! So that was a lot. At this time, we'll open it up to any questions. And I'm not seeing any. At this point, it could just be an issue that I'm having with GoToWebinar. If you have submitted any questions, we'll be able to pull them down afterwards. We'll be sending out the slide deck as well as the recording for this webinar following. So you'll have access to that. We'll send over some additional GDPR information as it relates to Tag Inspector as well that I think can be helpful as you start thinking about, how can you start knocking some of these different things off for your website and for your organization. And then also, if you've submitted a question, I'll pull that down, I'll answer it, I'll follow up via email. As always, though, please don't hesitate to reach out to us if there's anything we can help with. Any questions that you have, we're more than happy to help, in any sort of a way. So thank you all very, very much for joining us today. Be on the lookout for additional webinars that will be coming up in the next few months. And yeah, have a great rest of the day. Good luck with the GDPR prep. Talk soon. Bye.